We're happy to hear from you.
Thank you, Your Honor. May it please the court. My name is Frederick Levin. I represent Appellate Continental Finance Company. The district court erred because it improperly classified plaintiff's illusoriness claim as going to contract formation, not validity. It therefore considered it irrelevant.
Could you just speak up just a touch, or push the microphone up?
I'll try. I'll start over. The district court erred because it improperly classified plaintiff's illusoriness claim as going to contract formation, not validity. It therefore considered it to be irrelevant whether the plaintiff's challenge went to the whole of the cardholder agreement or was specific to its arbitration provision. That was error.
I'd like you to speak up as much as you can, too.
Okay, I'll do my best to speak as loud as I can.
Okay.
Forgive me
That's
if
right.
I
Thank
turn
you.
to shouting.
We're very interested in what you have to say.
I appreciate it. Should I start over, or did everybody hear at least what I said so far? Okay. I'll start with the premise of error. The district court considered it irrelevant whether plaintiff's challenge went to the whole of the cardholder agreement or was specific to its arbitration provision. That was error. Under the Supreme Court's severability test in Buckeye.
What difference does that make in this case? I mean, it seems to me your argument has to be, basically the principles of contract formation, and regardless in what state. And if you have an existing contract that can be changed without notice, it's illusory. If you and I have a contract and our term is that I can change it at any time I want without telling you, I just write down a little message, put it in my drawer, and that ends it, it's illusory. But if it's following notice and consent, that's Maryland law and everywhere else in Section 287 of the restatement, you can modify a contract with notice and consent. And so the question here is, this change clause have notice and consent? And your argument has to be that it requires notice, and then the customer's continued use of the card is consent.
So
the whole thing is sort of, you go into this notion of, well, we're going to separate out the arbitration clause when we have a illusory underlying contract. That's the argument. The Maryland case of Cheek just basically says you can't have a change without notice. That's so fundamental in contract law.
Well,
and so my question is, you spend a lot of time talking about trying to enforce the arbitration clause as consideration for consideration as a separate agreement. In some circumstances, that may be useful, but I don't see why that argument's useful to you here at all.
So let me take the second point first, which is I agree with you that the Cheek case says that notice is required, and that the clause
that's just fundamental contract law.
Right, in Section 287, and the contract
Yes.
says, as required by law,
Yeah.
that's the law.
Yeah.
There's consideration.
But that's not a separate consideration, or that's not a consideration in contract terms because you're required by law to do that anyway. You're not giving anything up. You're not giving anything additional.
Well, it says, upon notice, advance notice as required by law, we are doing what is required, and that is consideration.
Yes, but how is that consideration if there's no additional above it? You're required by the law to do this. Well, every contract is required, is contracted under law. And but that by itself doesn't, I'm just not sure that that's consideration. And at any rate, I'm not sure that there's consideration if you can unilaterally, under this change of terms clause, change the arbitration provision or any other provision. It seems to me that it gives you a very one-sided control over the contractual relationship. The whole, it's not a contract. You can just change it at will. This kind of
Well,
this kind of term, it just puts all the authority in you, and you give up nothing. And that's not a contract, because a contract is a bargain, and each side gets a little something.
well, the clause says, upon advance notice, right, we can change as required by law. What imposes the limitation is the legal restriction of giving notice. And I would just say.
You omitted the important part to address Judge Wilkinson's point. The important part, and under 287 and under all contract law in Maryland, is you have to have notice and consent. And the consent is a promise for a promise, which is binding. And the consent in this case is to continue using the card after you've received notice. And thereafter, the mutual arrangement, one's going to give credit and the other's going to pay the credit, and they have the terms and conditions. That's a promise for a promise, and that's traditional 287 law, where the consideration is the assent.
I agree.
But you don't say it.
Well, it's not stated in the clause itself.
It is. It basically says you, upon such notice as is required, and notice, and then continuation of using the card after having
Which is
received the
assent.
notice.
So, I mean, I think the clause itself does provide consideration. And I should point out,
It's a promise for a promise is your argument. In other words, you continue an arrangement, a mutually beneficial arrangement under new terms, as long as both parties assent. One gives notice and the other consents. Now, if there's no consent, there's nothing. It's unilateral.
Right, but the consent
is
is
the continued use of the card,
that
and
is
that's
correct.
explained.
And
Yes.
that is implicit in the change clause itself.
Well, it's in the language of the terms and conditions, too.
And in the terms and conditions. And I would point out that in terms of mutuality, the ARB clause gives an opt-out right, a unilateral opt-out right.
Well, that's my point. The consent is the continuation of the relationship.
Right.
That's the consideration.
I agree with
And
you,
and the customer can opt out with notice, and in which case, the change will not go into effect, the relationship will end.
I agree
But
with
that's
you.
just Section 287.
I agree with you,
And
Your Honor.
that's Maryland law, which has applied that from the beginning
but-
of time.
From those reasons, there is in fact consideration for the change clause. But let me come back to the
But
original.
before you do, let me ask you this. You did in fact modify this contract. You changed you eliminated the advancement of fees. What kind of notice did you give for that?
So the notice was given by posting the terms on the website. That's what's in the record. Now, the court made a finding.
And you think that's sufficient to post it on a website? That would satisfy the consent aspect of it? And
That kind of notice is routinely given in terms of service and other online agreements all the
Under
time.
Maryland law?
Yes, I believe that is sufficient. And the issue that the district court raised and made a ruling about, which was whether the notice was given in advance. And there's no evidence in the record to support that it
If
wasn't.
we take Maryland law, we're back into the cheek case. And this, I think that it ultimately is a question of Maryland law. The opposing side says you agree that this was a question of Maryland law. And of course, we can't decide whether a contractual choice of law provision applies to get us to Utah or Missouri law if no contract has been formed. You can't take a contractual choice of law provision if there's no contract to begin with. And the question I have is that is the district court found that under the Cheek case, that Maryland law frowned upon these unilateral change in terms provisions. And under Cheek, as I understand it, an arbitration agreement was illusory under Maryland law if one of these change in terms provisions was in the contract. The whole thing seems to me to feed into Maryland law. And it's hard for me to get around the Cheek case and the way Maryland law regards this.
So let me introduce 2 points. One, on the point about the concession. The district court did not accept, there was no concession, it was conditional and the conditions weren't met. And the district court didn't accept the condition. She did her own choice of law analysis at 511, 512, where I think the district court erred in not applying the applicable laws clause.
But can't Maryland law decide what's illusory and what's not? I mean,
Why don't you explain the Judge Wilkinson has put right to you the Cheek
Could I get an answer to my
case?
question, please? Isn't it up to Maryland law to decide what is an illusory contract and what is not? I mean, this is a question of Maryland common law.
Yes, Your Honor, but the argument here is that the choice of law provision under the case of Jackson versus Pasadena should have been
I
enforced.
thought you said there was no difference in the choice of law.
No, there is very much a
They
difference.
said you said that there was no
No, we did not
there was
say
no
that.
difference.
We very emphatically argued that there is a difference between Missouri and Utah law in the issue of consideration. On the consideration point, the Cheek case did not let you look to the broader cardholder agreement, but Utah and Missouri law would. So there is a true choice of
The Cheek case is totally supportive of your position, and you haven't explained that. The Cheek case says that changes without any notice are illusory. And the Holloman case said changes with notice are acceptable.
Okay,
And that's the Maryland law, and that's the restatement.
I agree with you.
Why don't,
Yeah,
don't
let me
argue with me. That's your argument to
Yes,
the point being
Let me
raised.
explain why we prevail under Cheek. We prevail
Well, I
under
just
Cheek
explained it to you.
for the exact reasons
But you haven't
just
made
said.
that argument.
Sorry?
You have not made that argument.
Well, we did in our papers, and if you allow me, I'll make it now, which is that the Cheek says if you give advance notice, as Judge Niemeyer pointed out, that is sufficient consideration, and the contract's not illusory. And here we give advance notice as required by law.
It didn't say that either. It said changes, quote, without any notice, end quote, render the agreement illusory.
Right, and here there was
So the
change
question
with
is
notice.
without any notice, that's
Right.
the key.
Right.
And the restatement 287 says notice and consent create a change to an existing contract.
And there was notice and consent here.
Well, I'm just telling you, I'm helping you respond on Cheek, and I can't figure why you haven't figured that out.
You know, I understand that, Your Honor, and I agree with you. And so that's why we prevail under Cheek. And we'd also prevail under Cheek for the separate reason that the Cheek has a four corners rule. And the way in which the change clause has to become under the severability doctrine, which Cheek embraces, has to become part of the arbitration provision. And the district court's analysis violates the Cheek rule because it relies on basic terms that are not terms of incorporation to move the change clause from the broader agreement into the arbitration provision.
That presumes that you're assuming that the change clause is invalid. Severability governs when there's an invalid provision, right? Has
No,
anybody-
under Section 2,
No, severability, you're applying the severability clause, right?
I'm applying the severability doctrine both under Cheek.
I know, but why are you at all? There's no question that a clause is invalid. It just, if the clause here said you could make a change without notice, it would be rendered illusory, the contract illusory under Cheek.
Right, and the question is, for purposes of is whether the arbitration provision included that
That's part of the
change clause.
contract. It seems to me, if you've got an illusory contract, you're dead.
Right, well, that's not what the Cheek rule provides. That part of it says that.
The Cheek rule says changes without any notice. Those are the exact words from the case. Without any notice, render the contract illusory. Your argument has to be that this contract provides for notice.
It does.
Well, why don't you make that argument?
I have, but I think, I think Cheek also, we prevail on a different aspect, which is the Four Corners rule.
All right, thank you.
May it please the court, Benjamin Carney on behalf of the appellees. The facts of this case illustrate why Continental's unilateral change in terms clause means that there is no delegation or arbitration agreement between the parties, and there never was. And again, looking back at the facts of this case, Continental's change clause allowed it to change any term of the delegation or arbitration agreements.
And it says it can change it upon such notice. In other words, it's conditioned on receiving notice. And it says if you receive notice and don't, you can opt out if you don't agree to it. And this is across the industry. I mean, every one of these things has this type of thing. You get notice. If you continue to use the card, you're agreeing to the terms. And that's nothing more than a restatement of Section 287 of the restatement of second of contracts. And I suggest that probably every state has that doctrine.
Judge Niemeyer, it is familiar to see those clauses that allow changes when a party continues to use, for example, a credit card, and that
Changes
language is...
upon notice. I mean, you know,
Yes.
I can't figure out why we're not talking contract law here. We had a contract formation based on the use of a card and the terms and conditions. We have, in that contract, we have a clause that says the lender can change it upon such notice as required by law. The notice is given, there's an opt-out provision. If the customer continues to use it with the change in place, he agrees and assents to the change. He doesn't have to agree, and he can get out, but that's not an illusory contract. It's a promise for a promise, and Cheek makes it illusory only if there is no notice, not any notice.
And Your Honor, that's what happened in this case, and that's what the arbitration and delegation provisions allow, is changes without notice, because
Well, how do you handle the language upon such notice?
upon
The
such
change
notice,
upon such notice.
upon such notice as required by law.
As required by law, right.
And Maryland law doesn't require notice of changes.
does.
When
It
there's,
does.
well, Your Honor, under the Cheek case, it can't, because that
Cheek
would
said
undermine.
notice without, a change without notice
Yes,
renders it illusory. If you and I have a contract which has a change clause and says I can change it at any point in time without telling you, that's illusory. I can make my change and put it in the closet, in the desk drawer, and you never know about it. But that's Cheek. But under Holloman, if I make a change, a unilateral change, and I give it to you, and you say, oh, it's okay, I'll continue under this, that is a contract, a change, and that follows the restatement.
Well, Your Honor, in the Holloman case, actually what the contract provided was, it said that there was a period of 30 days where no changes could be made to the arbitration clause. And during that 30-day period, after the person had received notice of upcoming changes, they could file for arbitration.
Well, sure,
So they
but I'm
had
talking
time.
about the principle of when a contract formation.
Yes.
We're talking about whether this change clause renders a contract illusory, or whether it provides that the lender can change the terms and conditions on notice with the opt-out provision that the customer can opt out if he doesn't want it.
And Judge Niemeyer, I would point out that there's a difference between the court finding that a contract is illusory and finding that there is some affirmative requirement under the law that notice be provided. So in the Cheek case, the Court of Appeals, the Supreme Court of Maryland now found.
But a contracting party has to follow the law in any and every event. And if you don't, as part of a contractual bargain, saying we're going to follow the law, I'm just perplexed as to how that is consideration, just saying, we're going to follow the law. Well, of course you're going to follow the law. But it would seem to me that something additional is required to make a contract non-illusory. And, you know, there's something that's fundamentally wrong. It doesn't strike me, it just strikes me as wrong to say that one party can change any term of an agreement upon their sole discretion. I mean, the clause itself seems to undermine the reciprocity that is the key to contract formation. Do you see what I'm saying?
Yes, Your Honor, I do see what you're saying. And in fact, as we pointed out in our briefs, Your Honor, the dictionary definition of illusory consideration is doing what's already required by law.
Well, let me ask you this on that
Yes,
point. The restatement treats a change like this as an offer, and the person's continued use as consent. And it does not require the additional payment. It's a promise for a promise. And after the change is made and the customer continues to use the card, the customer's getting the benefit of having credit extended, and the lender is getting the benefit of having the profits derived from the making the loan. And that continues, that promise for promise continues with the customer's assent. That's the nature of the formation of the amendment to the contract. That's what the restatement says, and Cheek is not in any way in tension with that. Cheek basically says a unilateral change without assent, without notice, renders it illusory. But Maryland follows directly, without any question, follows the restatement, whereas if you make a change and then there's assent and you continue the relationship, it's a promise for a promise. That's a binding contract. Isn't that your understanding of the law in Maryland?
Well, my understanding of the law in Maryland is that where there's a provision that allows one party to change the agreement at any time in their discretion.
They can change it at any time in their discretion with notice and assent.
Well,
Now, so they can initiate a change and they say, we can change our interest rate from 20% to 21%. And we'll give you notice of that. And if you assent to that, the next charge you get is going to be for 21%. If you don't agree to that, you can opt out. That's what this contract says. And that's so routine in commercial transactions. I mean, you would undermine virtually every financing terms and conditions that are being used in this country.
I don't think so, Judge Niemeyer, respectfully. And as I was trying to say earlier, there are many arbitration or delegation agreements.
No, I'm
which
talking
allow-
about contract formation.
or
Forget the
contract.
arbitration. That's part of
Yes,
the
Your Honor.
contract.
So there are agreements that allow unilateral changes, but oftentimes, something that's not found here, oftentimes they include that language that Your Honor pointed out, that changes will be effective if you continue using the card or if you continue using our service. And nothing like that is found in this change clause. This change clause allows any changes.
It has
upon
notice.
Please
as required-
let the lawyer speak.
as required by law. And here, Cheek does not require notice because it's implicit. I mean, all Cheek did, all the Supreme Court did in Cheek was to apply Maryland law to a contract and just basic contract principles. And in Cheek, the court held that where there is a unilateral change clause, that the contract is illusory, Cheek did not require any notice. They just found the
Sir,
result
Cheek,
or the
that's,
consequences.
Cheek
of-
said on change without any notice. They modified the word change, a change, and the words they actually used is without any notice.
And here, Your Honor, Continental didn't promise any notice. And in fact, they didn't give any notice. They changed the delegation and arbitration agreements in this case. They changed them. They told the district court they didn't change them.
Your point is that Continental essentially, in this instance, and whether this is industry-wide or not, fundamentally, the question is, when you have a contract, as Judge Wilkinson's alluded to, that's one-sided, that basically says, we will do it, and then you stick it on a website somewhere, and your language is such notice to you as required by law, not telling you when, not telling you how, not telling you anything. Stick it on a website, and so, okay, now you have an opportunity to opt out. That cannot be the import of the Federal Arbitration Act in terms of why we're even here, to the instance of whether a contract is formed. It cannot be Maryland law. If Maryland does not allow you simply to use the fact that you want to arbitrate as being consideration, that alone can't be it. And that without any notice does not mean notice that's just, I decide to put a balloon up in the sky and fly a balloon with a banner on it, that's notice. It has to have some input that notice means more than simply, I'm gonna stick it on a website. Assuming everyone even has a computer or can even look at the website. It has to have some indicia that there's an opportunity to consent, other than, I did it, and that's all the law requires me to do. But but the consumer has no idea what it is.
That's correct, Your Honor, and they can change any term of the agreement.
And the Supreme
and they
Court,
did.
to follow up on my colleague's question, the Supreme Court has been very vigilant in saying that when we're talking about contract formation as opposed to contract validity, that you've got to, a court decides those questions and you can't be, arbitration's an important tool, but at the same time, you can't push somebody into arbitration by ambush or with it's got to be an up and up relationship that, look, here's what's happening, and are you consenting? And as Judge Wynn points out, upon notice, that's awfully vague. But the real problem is that I think Maryland law digs at the fundamental unfairness of a supposed contract that has a change in terms clause and that allows one party at its own sole discretion. That's the way. It doesn't require, all it says is its own sole discretion. It's a very emphatic statement in the contract which lodges all of the power in the relationship to one party, unilaterally, to one side. And it seems to me that there's a basic idea of reciprocity that underlies contractual bargains before, and particularly with respect to arbitration. I think that's what the district court was getting at, that there's something wrong about this.
Yes, Your Honor, and it's basic contract principles that you can't have a contract when one side doesn't agree to anything. And that's what happened here, is Continental did not agree to any arbitration. They agreed only to be able to change the terms at any time. And an important point, I think, is that not only did Continental reserve the right to change the terms at any time, and not only did Continental admit in the district court that it provided no notice of those changes, and something that it didn't appeal. The district court found that there was no notice, and Continental did not appeal that factual finding.
You know, that whole validity versus formation, that's what your opposing counsel attempted to start it out with, the Buckeye check cashing company case. And I think it's fundamental to start there because the Supreme Court made it clear contract validity is a delegable question. But when you're dealing with the question of whether an agreement has ever been concluded, formed, is non-delegable. And so I think that's a distinction that factors in this case from the beginning, even before we get into the nuances of it, then we slide into the Maryland law process, into the Cody case comes into question, and then we get into the Cheek case in terms of whether this notice, which there may be a big difference as to what one would consider notice. And if it is any notice, well, I sent my dog out to bark in front of your door, and that was your notice. But it has no meaning. Notice has to have some meaning beyond I stuck it on a website. You can opt out, you can do whatever you want to. Terms are now changed. You didn't get to arbitrate that before I stuck it up there. It's up there.
And
That's the one-sided agreement.
Yes, Your Honor, and I think that what really plays into that point is that Continental not only reserved the right to make changes on a foregoing basis or going forward, it reserved the right to make retroactive changes. It said that any changes will not only apply to your ongoing business, but they'll apply to your outstanding balance. So in other words, if a customer wanted to file for arbitration or delegation over their account, Continental, over their existing account, Continental could change the agreement so that retroactively they wouldn't be able to arbitrate. So even if they gave notice, they could give notice that tomorrow your contract is going to change so that you can't delegate or arbitrate as of today. So that retroactivity further undermines the idea that there was any contract here, because they can not only change terms moving forward, they can change terms that, based on retroactively, they can change terms retroactively. And so it means that there is no real meaningful notice. And again, they admitted in the district court, and the district court found that there was no notice, and that's not something that Continental has appealed. They've admitted there was no notice, and they changed the agreement. They changed the arbitration provision, the delegation provision that required Continental to front the fees for the arbitration.
Well, wouldn't you think if they made a change without notice, the conclusion to reach would be that that change did not go into effect? But that doesn't undermine the contract term, which says a change is made upon notice and continued consent.
Well, Your Honor, I think that the fact that they changed the contract without notice simply illustrates what the contract says, which is that they can do that. They can change it without
Well,
notice.
a court could disagree with that, and court could rule that the change they made without notice was inadequate change. In other words, didn't affect a change. But that does not render the contract illusory if the agreements were provided for change, unilateral change with the assent of the other party and continued use of the cards.
So under Cheek, the Maryland Supreme Court said that the change clause in that case allowed the changes without notice. And so if Maryland law required notice, before a change, then the defendant in Cheek would not have been able to change the contract without notice. If there was an affirmative requirement.
I agree. We agree 100% that Cheek stands for the notice. Change without notice is illusory.
Yes, Your Honor. And so
There's no question. So the question in this case is whether this contract provided for change without notice.
well, and this contract only provided for notice if it was required by law. And here, there's no notice required by law because Cheek held that there was no notice required by law.
No,
Cheek held that it was an illusory contract.
Holloman said you have to have notice in order to be an effective change.
And again, in Holloman, the notice period was 30 days.
Well, it doesn't matter what the period was. Its fact is, the principle is that you need to have, a change has to be, you have to give notice and have assent.
And I think that at the heart of Holloman is the idea that the consumer, the party that's resisting arbitration, or that's not moving for arbitration, has to have had the opportunity to arbitrate under the arbitration or delegation provision. And where one party can change it, on a foregoing basis, retroactively, at their whim, then there's no promise to arbitrate. And one other thing that I point out is that Continental moved for arbitration on the changed agreement. That's
Well,
the only
you know,
agreement that they moved
there's
to
another
arbitrate on.
aspect of this case that really troubles me, and that is when you say required by law, as required by law. In the qualified immunity context, when you're talking about whether or not something has been reasonably established, Supreme Court has made it hard as heck to establish something that's reasonably established. Basically that there's a law. It's almost said it's got to be said precisely by the Supreme Court or a circuit court. That's it. And now we're talking about a regular consumer, and you throw out to him as required by law. What is that? I'm having trouble just even thinking of those two concepts in terms of, well, it's enough if you go and find a case somewhere in the books that said, okay, you required here. And that cannot be what any consumer out there can be held to do. I mean, when you're looking in terms of a credit card holder or whatever, who does that? I mean, it defies logic. I mean, the law cannot be just a mockery to the public. At some point in time, you have to, it doesn't take much for industry to simply say, notice that will be provided when, how, and where.
Yes,
It's
Your
a
Honor.
very simple thing to do in a contract. The reason you wouldn't put it in there, so you can do what you want to do, put a notice somewhere, knowing most people are not even going to care about it. That cannot be the basis of our laws in this country.
Yes, Your Honor, and I see that my time is up. I'll have a seat. Thank you very much.
Mr. Levin?
Yes. So I just want to start by reiterating the point.
But to answer that question, what does it mean to be as required by law?
Well, in this particular case, it means as required by the case law.
Where is that said in the contract?
Well-
All I'm seeing here is such notice to you as is required by law.
Right,
It
and-
begs the question, what is that?
Well, first of all, Maryland courts routinely enforce provisions involving required by law.
But tell me what it is. What is required?
in-
You're saying it is a term of art that Maryland defines
Well, in the
precisely so that
context-
everybody will know what it is?
In the context of this case.
Sort of
what's-
like what I said about the qualified immunity in terms of whether or not a matter has been established.
I'm focused on it within the notion of the Cheek Doctrine, and the Cheek Doctrine and the case Hulliman established what's required by law, which is that there has to be notice and an opportunity to consent by continued use. That's what happened here.
But I think you need to answer Judge Wynn's question, because if I understand what he's saying, and is that this whole thing is terribly vague, that what notice is terribly vague, that a consumer would have no idea what the notice was, and that it's illusory because the notice could just be anything. It's so
Well,
open-ended.
Well, but I think the answer to that is in what Judge Niemeyer said, which is that a court, upon consideration of what notice was given, and the covenant of good faith and fair dealing, and the law in Cheek and
There's no
and
Maryland case that rubber stamped a notice required, I mean, as vague and thin as this. Cheek didn't do it, Holloman didn't do it. That notice was not as vague and thin as
but
this
there's
one
an
right here.
underlying-
This is about the thinnest you can get.
There's an underlying principle which says that what is required is notice. And the question is did that notice occur? If it didn't occur.
But that's
then
it's virtually a throwaway phrase, because it doesn't have any content. It's as vague as it could possibly be, and all you're saying is we're obligated to follow the law, whatever that is. Well, of course you're obligated to follow the law. Everybody who contracts is contracting under law, but it seems to me that something a little bit more, you don't have to be detailed, but it has to be something more than just this vague, sort of boilerplate, throwaway phrase, which you can invoke at your sole discretion to change the contractual terms.
So where I think the point is.
It's too nebulous, isn't it? Isn't there a point where consideration can be so nebulous and so vague as not to constitute consideration at all?
So the consideration is the giving of notice and the opportunity to consent. Whether or not the notice was sufficient goes to whether the particular change can be enforced. And here's where I think this issue that you've raised gets confused with two different aspects of consideration. There's the consideration that is so little as to fail to give rise to a contract, but then there's failure of consideration, where the failure which constitutes a breach and doesn't give rise to a claim of illusoriness. So the legal rule, which is incorporated into our contract, says you have to give notice, and as Judge Niemeyer pointed out, then there's an opportunity to consent. That is.
And that notice is defined as any notice. That's the way you look at it, is any notice. Doesn't matter what, it's just, I don't know what it means. I mean, any notice.
But that gives rise, if the notice was insufficient, if there was a claim here that they didn't receive
We're not
notice.
talking about sufficiency. From the Cheek case, from Judge Niemeyer's interpretation, it's any notice. It's not a sufficient one, not a reasonable one, it's any notice.
Right, but that's where.
And that's
where the
your
covenant-
argument, right?
No, it's where the covenant of good faith and fair dealing comes in.
It was where he was leading you, is to go with
I would
any
think you
notice.
would-
If it's any notice, then any notice is good. It didn't say sufficiency, it didn't say you had to look at it and say, any notice.
Well,
I would think you would argue that the notice is the notice of the change.
That's correct.
And gives the opportunity for the customer to opt out.
Correct. And so that notice is given.
That's a substantive notice. I'm talking about the procedural notice. How did you do it? How did you give the notice? What you said in the notice is one thing, a notice of the change, but how did you give it? Notice has to have a procedural aspect of it too. I mean, that's understood. That what good is notice if all you do is have a notice that you write on a piece of paper and say this is of the change, but you never communicate it. So what we're talking about here is is how you procedurally gave that notice. And you say you did it on a website, you just stuck it up there.
Well, that is a common mechanism for giving notice in every financial product across the country.
Which assumes everybody has access to the website, right? Has to.
Well, that is true, but there are other
Which
modes
means
of access.
assumes
too.
everybody has a computer.
There are other modes of access as well.
What? When you put it on the
In
website.
Mailings to the customer.
Website, it's on the website. You didn't say anything about mailings, you said website.
Well, they get a bank statement every month.
Website is where you put it. That's the only place you put it.
So the issue in Cheek is giving notice and the opportunity for consent. If that, and that's all that's required, that's what was given here.
Thank you, sir.
Thank
Now, let me ask Mr. Levin,
Yes, sir.
let me ask Judge Niemeyer if he has further questions. All right, thank you, sir. We'll come down and recounsel and move into our next case. Mr. Brotherhoff?
Thank you, Your Honor, and good morning, and may it please the court. My name is John Bredehoff from the firm of Kaufman and Knowles, and I represent First Advantage Federal Credit Union, which was the defendant below and is the appellant and cross-appellee here. There are a few subsidiary issues in this case. Whether or not there can be a bailment by a general deposit of money, whether the court erred, committed clear error on a 59E motion by not adding punitive damages, but mindful of the stare of Judge Albert V. Bryan Sr., I will cut, I think, to the heart of the case, which is what happens under the Virginia iteration of the Uniform Commercial Code when a wire transfer, or in this case an ACH, goes to a financial institution like the credit union, and it has a valid account number, but the name doesn't match the account
Let me
number.
ask you this, is there a, in the course of the bench trial, did the district court make a finding of fact that an individual within First Advantage had actual knowledge? Was there a finding of fact that the district court made that addressed, that applied the actual knowledge standard on an individual basis, and that there was some individual at the bank who understood the fact that the beneficiary's name did not match the name of the account? Was there a finding that an individual had actual knowledge of the mismatch?
I reread the district court's decision last night and again this morning at 5 a.m. for that very point, and I do not see such a finding. Rather, what the district court found was that an individual at the bank should have examined further,
Well, but that's not what I'm asking.
and the answer to your
I am
question.
asking not what he should have done or could have done. I am asking whether the district court made a finding of fact that an individual at the bank had actual notice of the mismatch.
And the answer to your Honor's question is no. And that is why the district court's decision needs to be reversed. Because it imports all of these diligence and nebulous negligence concepts into the determination of whether there was knowledge of the mismatch, misdesignation of beneficiary. But that is exactly what the Uniform Commercial Code and the NACHA rules themselves, the National ACH Association, which is amicus in this case and supports our position, that is exactly what the Uniform Commercial Code says.
There's a problem in, Studco is an innocent party here.
So are we. They're innocent.
I know, but what I'm saying is Studco, they correctly noted the beneficiary of the check, and they wrote the check out in a proper fashion. And they've done nothing wrong here, and yet they're going to be saddled with the damage and the loss that was inflicted by the fraud. So does that aspect of it trouble you, that that Studco is completely innocent in its own behavior and that they are going to be left to bear the full brunt of the fraudulent activity?
It has troubled me, but it is irrelevant to the 207 analysis. Now, let me drop a footnote, if I may, about the complete innocence of Studco. We talked about contributory negligence. That doesn't apply to the statutory claim. It only applies to the common law claim.
But did Studco do anything wrong? They didn't.
Sure they did. Sure they did. If you look at this email that says, change our bank, I mean, there was supposed to be a change. It was supposed to be a change from JP Morgan to Bank of America. What they got was an email saying change from JP Morgan to this 1,000 times smaller credit union that's not allowed to have customers outside of Virginia and Northeast North Carolina. And they got it in an email that had 4 punctuation letters, typographical errors, and it was from studco.net and said in the signature block, the correct one, studco.com. Anybody who gets an email where the sending person doesn't match their signature should at least call.
But you are.
But that's a
You
different issue.
are under Virginia law, which adopted the UCC.
Mm-hmm.
It was promulgated, like I remember it quite well, with it in mind that a bank such, or an entity such as yours, if you got something and you had a bad name on it, or you had the number, if the number is proper for the identification, that's gonna be enough. And
That's right.
apparently that number matched whoever that person was.
That's right.
Up
She-
there.
She was
And
scammed too.
Judge Wilkinson is right. I remember that coming up. That turns into some bad situations where it feels like you know there's a mismatch, or you maybe have a duty for the mismatch, but the UCC says if you do what that number says and it matches that up there, you're good.
The UCC, in fact, Judge Wynn, says we impose no duty of inquiry, no duty of diligence in determining whether they match. There is no duty.
Well, that's in order to accommodate the thousands and thousands of transactions that occur and are done by computer. And
Billions and billions.
yes, and apparently this record shows that there are thousands every day of mismatches at that particular
at that
institution.
tiny
Yeah,
credit union.
Yeah, and that they can't look at 70,000 matches every single day and run them down. So the UCC, in order to facilitate the transfers of money between banks, relies on what Judge Wynn says, that basically the account number, the ACH process.
That's correct. And the comment to
Unless
section,
there's actual knowledge. And if there's
Right.
actual knowledge of a mismatch, what would constitute actual knowledge?
well,
And
if you-
is it the actual knowledge of the bank, or is it an individual, or how does that factor in?
that is an important question, and I had hoped to spend a lot of time on it, because the court below and the opposing brief from my colleagues across the bar spend a lot of time on section 202F and say it imposes a due diligence standard. 202F talks about when a financial institution has knowledge, somebody there knows it, and then has to tell somebody else to take action.
But I mean, I suppose organizational knowledge would always be there. So I suppose your argument is for the actual knowledge standard to have any meaning, it would have to be an individual,
Someone, a person.
somebody.
And that's,
And I come back to the question, my question was really a very simple one, whether there was a finding that the district court made that any individual at First Advantage had actual knowledge of the mismatch.
And the
That's-
answer to
That's
that-
what I think,
no.
that's what, you can argue that that's what the code requires.
That is what the code requires, Your Honor.
So, the concern that I have, and I don't know whether it's a valid concern, but if we require manual checks, and sort of take leave of the electronic, of electronic capabilities, and actually require manual checks on a name or on a mismatch, as opposed to allowing the bank to consummate a transaction based on account numbers alone. I wonder if we're not just sending banking back into the dark ages, and requiring banks to do something that is going to be quite laborious and is going to add a good deal of delay toward transactions, and along with that delay, there's going to be added expense that somebody is going to have to pay, perhaps a depositor or whatever, but there would be fees levied one way or another to cover that delay. And so, given the fact that an awful lot of banking transactions are conducted simply by the number on a check or the number on an account or what have you, and this could, I'm wondering, is this really a crippling imposition upon the banking practice? Or is this just a parade of horrors that's been thrown up before me? Or in real practical terms, is this a crippling imposition on modern banking as we know it?
I think if the court has read amicus briefs, which include the National Association of Federally Insured Credit Unions, the National ACH Association, the organization which they're.
But how real, I mean, tell me, how real is the danger?
It'll come to a screeching halt. A screeching halt. Now, the answer to that my good colleagues across the bench would say is, well, little credit union, have your IT people go into the software that you bought to screen and change it around, change the parameters, make it catch only big problems. But, you know, we're not Bank of America. We're 1,000 times smaller than Bank of America. That would impose an error rate, I think, that would be even worse. But more than that, their expert testified at trial that the use of the software we use, which is out of the box, we didn't change it, most credit unions, over 1,000 credit unions in the nation use it, it's recommended by the National Credit Union Administration, was not negligent. So
Well,
even if
negligence is not the standard under this, right?
it is not, nor is due diligence.
I mean, if you look a little broader under the nature of our regulations, the whole checking system relies on the very same principles.
Correct, Your Honor.
You write a check, and the person who dealt with the thief ultimately bears the loss, unfortunately, and the people in between are protected by the process established by the code. And here, the person who dealt with the thief was Studco, unfortunately, and I suppose they were innocent in the sense that they trusted the email, but a little telephone call or a confirmation email to Olympic would have solved the whole problem.
Or even sending an email to the address they had on file for Olympic because they've been dealing with them for many years, and the guy who purportedly sent the email but didn't visited there once a month.
Let me ask you a question about your privity argument, if it's before us properly.
Yes, sir.
If your argument, if we accept that privity argument, and you say it's Stucco's bank that ought to be the one that actually is dealing with this, and that is who they should sue.
That's what.
Why would you make no effort, or did you make any efforts to have that bank brought in as a necessary party? Because it seems like, I don't see how your entity cannot be a party, because that bank would still have to show you had actual knowledge of it, I think, and you know, and it would probably want to recover from you, I would think, in order to be able to do it. But I'm just dealing with the privity argument that if that exists, then it seems like to me you would have, you know, moved to have them added as a party, a necessary party.
Well, we didn't do that because we knew we had no actual knowledge. But You're right, Judge Wynn, because the statute says who's liable, and Judge Wilkinson, this goes to your earlier question about what if they are innocent. The statute says there are two people who can be liable. The beneficiary, which is our member who is impecunious, or their bank. Their only argument to that, what Natcha calls the privity argument, is that we didn't make it. But if you look at our reply brief, our proposed conclusions of law, Joint Appendix 503, 504, goes on and on about how you cannot recover from us, you must look to your bank. I have about 20 seconds in which I'd like to distinguish all 14 of the cases they cite.
All right, can you do that on rebuttal?
I
Because
can,
you're
and I
over
will,
time.
and I will end early.
Good.
Oh,
I
I'm
asked my
sorry.
co-panelists, Judge Niemeyer, do you have any? Okay. Mr. Patel, we'd be pleased to hear from you.
May it please the court, my name is Chirag Patel, along with my colleague Mariah Jaworski of the law firm Clark Hill, on behalf of the plaintiff, appellee, Studco Building Systems. The district court, sitting as the fact finder in a 3-day bench trial, heard from First Advantage's head of compliance, head of ACH transactions, and Studco's expert witness, the head of the former president of NACHA, the organization in charge of creating the ACH rules, and correctly held in favor of Studco on its UCC misdescription of beneficiary and its bailment claims. The misdescription of beneficiary claim concerns First Advantage's processing and deposit of Studco's funds, while the bailment claim concerns First Advantage's failure to care for those funds after they were deposited in the customer's fraudulent
You
account.
agree that actual knowledge is required?
Your Honor, the standard for knowledge for an organization is set forth in 207 and explained in the comments. So in 207, it says that a bank only has knowledge for a misdirected transfer if they know that the number of the intended beneficiary and the account number doesn't match the account.
You agree that's actual knowledge?
What the statute says, and this is in the comments, is that there's a standard for organizational knowledge. And so it's what the statute says is that if a person knows about it, then there's actual knowledge. However, there's the code points you to 1-202F, which says that which imputes knowledge to the bank at the time the misdescription would have been brought to the bank's attention if it had exercised due diligence. The code says that organization exercises due diligence if it maintains reasonable routines for communicating significant information to the person conducting the transaction, and there's reasonable compliance with those routines. So there is an organizational standard that is embodied within 207, and it points the reader to 202F. When you read these together, it makes it clear that the misdescription must be known by the person conducting the transaction to have liability. However, the bank must also have reasonable routines in place to communicate significant information that would lead the bank to obtaining knowledge of the misdescription. And on this point, I'd like to point the court.
I mean, I guess one could think we're talking about who has to have the knowledge, and we're talking about an individual or an organization or whatever. But regardless of that question, the ultimate standard is one of actual knowledge, and it's under the code here. And when I looked at the district court opinion, there were an awful lot of statements about what the bank should have done or might have done, and there were statements about what was a commercially reasonable practice, and there were allusions to reasonableness and everything, and much of the opinion sounded to me in negligence rather than actual knowledge, and there were disconcerting references to commercially reasonable practices or that kind of thing, and they may be. One can argue about whether the data safe program was a reasonable practice or whether it wasn't, but I just thought that so much of the district court's opinion bottomed out on reasonableness and on negligence phraseology,
Sure.
and I'm troubled by that.
Sure, Your Honor. The commercial reasonableness language, that all relates to the bailment claim, but I want to point the court specifically, the comments state that there needs to be reasonable routines to convey information within the organization. And I'd like to read just one quick sentence from a 10th Circuit case, the First Security Bank versus New Mexico versus Pan Am Bank. And they say that although a bank has no duty to affirmatively search for conflicts between the beneficiary names and account numbers for incoming wires, it may not escape liability if it, before it pays the wire, gains knowledge of the conflict by any means. And this strikes the balance because it considers the bank's right to automated processing of wires. However, if there's information that comes into the organization that tells them that there's a misdescription of beneficiary,
Isn't the likely consequence of your position that the bank would be required to sort of manually go through deposits for evidence of a mismatch when so much banking today is done by numbers? A bank will look at the number of the check, and a bank will look at the number of the account. And that's critical to commercial processing. And if you have to go with a manual check, and you say, well, the numbers are insufficient and we're going to go by whether the names match or mismatch. Well, names shift all around. I mean, some people, their names, their middle initial may be missing, or there may be a letter missing, or there may, some people write out their full name, others don't. So is manual review what you're asking for?
absolutely not. All what we're asking for, which is consistent with the district court's finding, is that the banks will continue to continue automated processing. However, if they receive extrinsic information that there is a problem, they need to convey that to the right person so they can stop the transaction from occurring. That's what the UCC says.
The argument is that the data safe program sends forth these warnings, okay, and that the warning is a notice of sort. But the argument is, well, the data safe program does emit these warnings, but that they are absolutely voluminous, and that they're just overwhelming in their number, and there's so many of them that it's in effect not much of a warning at all.
That contention was rejected by the district court, and that was a contention that was made by the witness during the hearing. But then on cross-examination, I asked her, I said, well, of those warnings, how many of those actually relate to mismatches? And the testimony was, well, we don't look at them, so we don't know. And they conceded that there was all kinds of different warnings. So they didn't actually.
I thought there was evidence that just at this bank, there was over, I don't remember the number exactly, 70,000 every day.
They said that there were hundreds to thousands, in very broad terms, of just warnings.
Yeah.
And then if you look at the full record, including the cross-examination.
And the problem is, if they left a junior off of a name, or they left a middle initial out, or whatever these warnings may alert, or they used John instead of Jack, or in other words, to match these names with the account numbers are unique, and the system is dependent on that. And it seems to me that what the system is designed to do is to let the numbers govern unless they have personal knowledge of a significant problem, and there's no finding of that in this case. So it really comes down to you're requesting a greater or a different method for receiving ACH deposits. And the ACH deposits are probably in the millions of billions every day. That's the essence of the whole banking system. And, but even at this bank, bank couldn't operate. They would just collapse if they had to monitor the differences in the names of every deposit.
You know, as a matter of fact, that contention was rejected by the Supreme Court, or sorry, by the district court. And the district court, as fact finder, was closest to the facts in this case. The district court, again, found that there was insufficient support for the contention that it would be untenable for them to be able to review them. And to the contrary, our expert witness testified that they would be able to review they could set up filters as well.
Doesn't that get into a negligence inquiry as to what the bank should have done or what the bank could have done or what have you? And doesn't that stray from the actual knowledge standard into a different negligence-based inquiry as to what the bank could do or might do or whatever? Because that is different, I think, as to whether an individual has actual knowledge. You see my question?
I understand your question, Your Honor. The organizational knowledge standard is within the statute. It's explicitly and expressly referenced within 207, and it states that organizational knowledge is either actual knowledge or when information would have been learned if the entity had exercised due diligence in communicating significant information.
But on that point, look at the UCC commentary to Section 202, which I think is, Virginia has adopted the commentary to the UCC too. And it gives the example of a bank or an entity in which a clerk, the question whether a clerk has knowledge or notice in Department A, that would only exist if that notice goes to Department B, only if it's directly communicated to A. So in other words, this business of organizational knowledge is not a constructive knowledge. It has to be actual knowledge, and that section right there implies that it has to be from employee to make sure it's being communicated to the one that's supposed to be getting the knowledge. So that has to be alleged and it has to be shown in this case. Don't you agree?
That provision supports our argument, Your Honor. That provision says that notice is effective from the time that employee A communicated that information to community B or should have communicated that information.
Yeah, but see, all of F under 202, all of F is directed at when a particular employee gets notice. How does the institution get notice? And it provides the structure when it should have in the structure, but it still rests on the initial proposition that even the individual had to have that, some employee had to have actual knowledge of the problem.
If you look at the definition of organizational knowledge within the statute.
Well, that's what I was
Yeah.
looking at, and Judge Nguyen was just reaffirming, it seems to me in the commentary, that notion that the problem that is being addressed is when an employee, let's say a very low-level employee sees something, is that imputed to the corporation or the entity? And the answer is it may be based on 7, which is a should that employee have notified and who would have notified. But it still starts with the notion that the employee had actual knowledge.
Sure, Your Honor. So I want to make one thing. The standard is correct, and in fact, the standard says that as long as they establish these routines and they follow those routines, even if the information doesn't get there, the bank is still not liable. So it provides them some protection, and that prevents the issue that is here, which is where banks will create silos to prevent the transition of information from happening because they want to avoid liability. But I also want to point out that it wasn't only the information within the warnings that the district court found created that knowledge. It was not only that, it was information that was obtained by the interactions with the customer when she opened the account that would have given them information. It was the interactions with the tellers that was highly suspicious. It was the other warnings that were created by the computer system that First Advantage said would have been looked at by an individual. So there's all these human interactions that were looked at that would have led them to have significant information that would have led them to find the misdescription of beneficiary.
You're suggesting that a bank would deliberately set up a system whereby only one entity within it would learn it and not communicate it on purpose to another one to avoid the actual knowledge?
You know, that was what the amicus argued. The amicus said that if you imposed a due diligence standard, it would impose liability on us for making an effort to communicate
But
information.
under your theory, there's always going to be actual knowledge on the part of the organization whenever a warning is set off by the data safe system, that would be sufficient. Simply the warning from the data safe system, that would be sufficient, as I understand your view, or it would at least be argued to us in future cases, that would be sufficient to establish organizational knowledge. And that seems to me a broad, very broad proposition. And what's nagging at me at bottom in this case is that I think in the present day that banking is done by the numbers. And that's what makes the system efficient, and that's what makes it go. And I don't want to strike at that basic proposition that in our modern age that banking and commercial transactions are done by the numbers. And what the concern I have is that it may result in an individual injustice on occasion, and I think that the plaintiff's case has a lot of sympathetic aspects to it, and I'm drawn to it as a matter of equity, perhaps. But sometimes you have to have a result that you're not all that happy with in terms of what the plaintiff is asked to absorb in terms of a loss. But we do this for a larger public good, and that is efficiency in banking transactions that allows many different parties. Or that would otherwise pose to many different parties a great deal of delay and a good deal of expense. And so what it seems to me, we're asked to put up with a result that I'm not thrilled about, okay? But to do so because there's a larger public good involved, the larger public good being, or maybe danger being striking at the fundamental characteristic of commercial transactions, which take place by the numbers, and the numbers are more reliable gauge in most cases than possibly shifting names. I've taken up a good bit of time with my questions, so I'm going to give you some extra time. But this is I'm trying to be quite honest with my concern about what it is.
Yeah, Your Honor, I think the response that I can give to that is that even in a situation, once again, the district court did not only rely on the reports that were in the systems, they also relied on information that was received by human beings at the banks that were suspicious, and that the court found, as a matter of fact, which should have some deference, that information should have been communicated to stop the ACHs. However, what the UCC says that as long as they establish reasonable routines for communicating that information, and if they follow those routines, even if the information doesn't get there or if it gets there late, they're still off the hook. And so they can continue to process everything in an automated way. And all they have to do is, if they receive significant information, and what may be significant could be different on a case-by-case basis, they just need to have a reasonable routine for communicating that information to the person who's conducting the transaction. If they do that, even if it falls between the cracks, there is no liability. So the liability in these instances will be very rare. It will not slow down the banking system at all. It's only in the rare cases like this one where you have significant instances where there are warning bells, red lights.
Well, how do we define, you're asking us to add judicial standard of significant, I don't know what we're gonna call it, and how do we define that in view of the fact, the way the code treats these things? In other words, we have thousands and thousands daily of these misdescriptions. And the question is, how do we determine that they're significant? I guess your answer is that we then put in additional computer systems to analyze them, and then do we do that based on whether the name is totally different or is just partially different, or I mean, I'm not sure what would require. And then if we're doing all that, wouldn't we be rewriting the code?
All the language I'm using is in the code. Significant information to convey is in the code. And so
Where's that?
this significant information is in 1-202F, and it says that organizational standard.
Well, I know, but I think you're misreading to F. F, I think, is how to get actual knowledge by an employee imputable to the entity. In other words, it's addressing the situation of how does the entity have actual knowledge from its employees. And, but I don't think that imposes a standard on the system of discovering misdescriptions and mismatches and whatever we have. And what impresses me is that in this bank alone, I wish I had the number at hand, but in this bank alone, every single day, we're talking about many, many thousands, tens of thousands of mismatches. And the question is, there's no way, no standard that's currently established to define what a big mismatch is and what a little mismatch is. I mean, the mismatch may be just a husband and wife, and they have the same account. So you have Mrs. Jones and Mr. Smith, they happen to be married and using their professional names. I mean, would that be a significant? I have to stop the whole system and pull it out, and they're probably, there's as many mismatches as there are in what we all write names or describe accounts. One's a trustee, they write the word trustee on one check, and there's no trustee on the other check. And you can just go through them and figure out how that would be irrelevant or actually bogging down the whole banking system. And so if you go by numbers which are unique, that's a certain way to do it. I mean, they could leave off the name. They happen to provide the name, but of the account. You know, the thesis, I think, of the UCC, and I'm just adding a little bit to what Judge Wilkinson observed, the philosophy of the UCC is that to facilitate commercial transactions, we put the burden on the person who dealt with the thief. And whether it's in checking accounts or the ACH or whatever. And in this case, the burden has to fall, or does fall legally under the code, I think, to Studco. And Studco last dealt with the thief, and the question is, could Studco have avoided? Maybe a few little checks, it would have probably avoided it, but Studco was somewhat, it was a victim, but so was the First Atlantic, and a victim, and so were the intervening banks who transferred this. Who was J.P. Morgan? Who was the?
They were the originating bank. There are
Originating
yeah,
bank. So
yeah.
they're a victim too. I mean, because they transferred an account with a mismatch, and it could have been along any number of banks in the system, and they would have all been delivering mismatched accounts. And we just can't isolate that and impose that kind of liability and have a sophisticated banking system. It seems to me that's my big take on this, is that equities are always difficult in these types of commercial transactions. And Studco was clearly victimized. I looked at that letter, and I know your opponent points to all the little things. I don't know if I would have observed all the missed periods and things like that. I might have noticed the different addresses, website addresses. But I think when a whole relationship, a banking relationship, is changed, to pick up a telephone call and call Olympic and say, is this something we should be concerned about? Are you going out of business? You need extra money to credit or whatever? And they would have uncovered it, but anyway, it's a difficult case. It raises, and of course, the code is always a very detailed, thought-out process, and I think all the states have virtually adopted the code, so there's a uniformity there.
I'm well over my time. I can respond, but
If the judge will, the chief,
Of course you have time to respond to that. I always like to give litigants the last word, so please respond.
I appreciate it, Your Honor. Thank you. I'll just note a few things, Your Honor. The court, again, made factual findings, and they were close to the facts that related to Studco being the victim of the fraud. And they found that there was no evidence that we breached any duty of care in sending the email. So the First Advantage did not establish a duty of, they argued contributory negligence. They did not establish that our cybersecurity practices or us falling for the email fell below any duty of care. So we were entirely the victim in this case. Second, I want to reiterate that the information that the district court relied on, that providing knowledge, was not just the warnings in the systems. It was human interactions with the banking customer that was conducting the fraud. That was again, these are factual findings. The district court was in the best position to observe the witnesses of both First Advantage and also from our expert witness. And they said that based on what was happening in these accounts, and that the tellers, they were trained to detect this, but they should have seen it. They had systems that created warnings that were reviewed daily by individual human beings, and if they looked at it, that information would have been conveyed. So this is a very rare and unique case. We're not just talking about information within a system. We're talking about multiple interactions. I think the customer was at the bank at least 15 times, and every one of those interactions, and if you look at the record, it shows that they admitted that all of these were suspicious transactions, and as the 10th Circuit said, any means that leads the bank to this description creates knowledge.
You're looking in hindsight too, because they did ask her about the money, and she explained she was in a real estate operation, newly employed, and would have these transactions. And so, as you know, real estate does use money in the range of $100,000, $50,000 at a time, and I think, wasn't that her explanation?
That was a factual finding, and the facts as reviewed by the district court were that was suspicious enough to cause it. And that is not clear error, and they haven't established that was clear error. So I think if we're talking about the standard, that may be a no-go, but when we're talking about what the court observed as being sufficient to create that knowledge, that should be, the court should show deference to the lower court on that issue.
Oh, thank you very much.
Thank you, Your Honor.
You have some rebuttal time, sir.
Thank you, sir. The question with respect, Your Honors, is not whether there were fishy things going on with the account. There really weren't. The first thing that they say was fishy, she had 2 other accounts. She'd been with us since 2010. There was a discrepancy in the address. That was the first thing. They checked it, they fixed it, okay? All of these other fishy things, one was an Office of Foreign Asset Control alert about an outgoing transfer that turned out to be a false positive. We cleared that. None of them were anything to do with the incoming money or with the knowledge that the account number did not match the beneficiary. These were all BSA, Bank Security Act things, and there's no right of action to enforce the Bank Security Act. We remain with the law, and I'm uncomfortable about this to some extent.
As a matter of curiosity,
Yes, sir.
Was the real culprits ever run down?
No, they were in Dubai, Nigeria,
So they got away with about $500,000.
more than that, a little bit more than that, Your Honor.
Your argument kind of at bottom is that numbers are more important than names. And, that probably is where we are in this world, that at least as far as commercial transactions are
It is, Your
concerned.
Honor.
Hold on a minute. As far as commercial transactions are concerned, that numbers probably are more important than names. It's a sad development. and an impersonal development in my view, but I think that Judge Niemeyer makes a good point when he said that the code has as a basic emphasis efficiency in transactions and allowing transactions to go forward in a less impeded way. But, you know, I guess this is a environment in which the modern commercial world finds itself. And it's not an altogether happy development, but I understand your argument about the broader consequences that would ensue if we started fooling around with the ability of banks to process deposits based on account numbers. I think when we depart from that, that carries significant risks. But it's just not all that happy situation. It's an impersonal situation, and it's not the way commercial transactions used to be.
I am never happier than when I go to the bank at the basement of my office in Norfolk, and they all say, "Hello, Mr. Bruderhoft." I like it when we know the people we're dealing with. Unfortunately, when we don't know, or we have reason not to know, we need to be careful. But the first thing, Judge Wilkinson, that you said is that names are less important. Comment number 2 says that. It says the name, quote, "plays no part in the process of payment." Judge Niemeyer, your analysis, of course, of 202F is exactly on point. It deals with when someone has knowledge within the organization, whether that's imputed to the organization. And most of what I was going to say the first time around was that every case cited on page 33 and 34 of their brief for this organizational standard deals with that, not with whether the organization should have had diligence to get knowledge, but moving the knowledge within the organization. Your PAF case, for example, 2 certified letters were sent to the organization, but they didn't go to the right person. Well, that was imputed. And the other cases are to the same effect. Their cases, they reject a due diligence standard or a duty to obtain notice about the mismatch. I mean, that's the Wells Fargo case, the Shapiro case, the Valdez case. They're all the cases that they cite. We cite 10th and 11th Circuit cases, First Circuit Bank and Weatherall. They're all to the same point.
All right, thank you.
Your Honor, if I may have 10 more seconds to address a question
Yes, you may.
I normally wouldn't ask. Judge Niemeyer, the testimony about the warnings was a question, why don't you read all the data safe warnings and mismatch names? Answer, because the system generates so many, it wouldn't be a benefit to do so. Question, how many does it generate? Hundreds to thousands. It depends on how many transactions. So those are all mismatch names, and it's hundreds to thousands a day.
Thank you.
Thank you, I appreciate the court's
All right,
attention.
well, we thank you both. We'd like to come down and greet counsel, then we'll proceed into our final case. Thank you so much for your argument. We appreciate it. All right. Thank you so much. Thank you very much.
A while back, that's true, I was on the court then.
I forget how old. Sir?
Nice to see you. She, lawyer.
I sure am. Thank you very much.
Jay, while they're changing, I'm just gonna call them for a second.
Well. Niemeyer's gonna take a break.
You just do whatever you want to do, why don't we just take one?
Hold the fort, pal.
Would you like me to call recess?
Yeah, we just take.
This honorable court will take a brief recess.
Okay, Mr. Castor, whenever you're ready.
Thank you, and good morning, members of the panel. My co-counsel here is Melanie Fay. I'm Bruce Castor from Philadelphia for the appellants. There's been extensive briefing in this case. The district court in Maryland dismissed the appellant's petition below on standing grounds, and not only has the issue been briefed by both parties, but the Brennan Center has an amicus brief. And we're seeking remand to the district court for further proceedings on the issue of standing and perhaps on the merits of the petition. The basic factual recitations in the petition are that appellant organizations and some individuals who are voters in Maryland did a statistical or a data analysis of the 2022 federal election and found irregularities that it thought, collective appellants thought, ought to be addressed by the appellees, the Maryland State Board of Elections. And while I know the court has read all of the briefs, I want to approach this from a slightly different angle than I approached it in the original brief, from a constitutional angle. Article 1, Section 4 of the U.S. Constitution creates the peculiar situation where each individual of the several states decides the time, place, and manner for federal elections. It primarily relates to the House of Representatives, but over time it has come by amendment to include the Senate as well. And if in 1787 or 1789, Congress from that point forward chose to leave that alone and did nothing at all, each of the individual states would have developed their own mechanism for deciding how federal elections every 2 years, or if there was a special election, would be constituted.
Focus on the standing question, the Article 3 standing. And the question seems to pop out here is there seem to be some generalized information that's given or generalized possibilities, but is that enough for Article 3 standing?
Well, Judge Wynn, that was the reason I wanted to approach it from the opposite way that I did it in the brief, because the situation that has arisen is, I suggest there was no possibility that Congress could have anticipated that when it invoked the second clause of Article 1, Section 4, that Congress may from time to time regulate elections, where the first part of the clause says that the states shall have the authority to determine the time, place, and manner of federal elections. Then, so while the Constitution gives this presumptive jurisdiction to the states to supervise federal elections, the next clause, it takes it away by saying, but we can change that if we want, keeping Congress as the supreme architect, the supreme decision maker on how elections are to occur.
But I'm not sure you're answering Judge Wynn's question, because he wanted to know why, he wanted you to address the standing question, and I want you to address that too, because Article 3's limitations on judicial authority are very meaningful, and standing has within it a requirement of particularization. And I don't understand how your claim of injury is in any sense particularized, because it seemed to me that any voter could come in with a conclusory assertion of vote dilution, and without more, satisfy the Article 3 requirement. And so this is where I'm hung up, because I don't understand exactly how your vote was diluted, other than in some highly general sense that everybody's vote is theoretically diluted. And that's a preliminary question that I need to have answered to my satisfaction before we even get into the merits and the fact that the notice was sent to all the wrong people. But the standing question is fundamental, I think, in these vote dilution claims. And I would just like how you separate yourself from members of the general public.
Well, on the issue of the particularized standing, Your Honor said could come in with anything unsubstantiated. Our clients argued that they could come in with things that were substantiated and could demonstrate that in their particular instances, they were unable to feel as though their vote was properly counted. So it wasn't particularized to all voters. It was particularized that if you believe the following things that we allege, our members, and particularly Ms. Sullivan and Mr. Morsberger, our vote was not properly counted or canvassed.
Well, I'm not sure that's in the record at all. I thought the only statement onto that is whether the ballot was blank, and there's no evidence that the plaintiffs in any way cast a blank ballot. It's only that there's a fear because of the statistics you have that they don't know or they're worried about casting a blank ballot. That's on your third count, which is there's a standing question there too, probably. But you allege with respect to the first count and the third count, basically, that your vote was diluted. That's the injury that you claim. And it seems to me that that is a generalized injury unless you have some comparative is diluted with respect to what. But if it's everybody's vote was diluted because of a voting irregularities, that's probably needs to be addressed by the commission and by the legislature.
Well, the trial court applied the factual subject matter jurisdiction test and not a facial subject matter. So the trial court did not permit or did not credit affidavits and permit the introduction of specific evidence on that point. So we didn't get an opportunity.
Well, what is your
advance
allegation
that.
of particularized injury with respect to what you've alleged? You've alleged irregularities in the 2022 and the 2020 elections?
2022.
2022 elections. And what's the particularized injury that the plaintiffs are alleging?
That they cannot be confident that their votes were properly counted and were properly credited in the 2022 election.
Well, if somebody's not confident that it was counted, it's pretty speculative, isn't it?
Well, they wanted to present evidence on why that assertion was reasonable, but didn't get an opportunity to do so.
And if it wasn't counted, or it was, if it's specific evidence that they weren't counted, but you're not even making the claim it wasn't counted. The only claim you make in that direction, I believe, is that there was some blank ballots cast during the election, and you don't know whether yours was blank.
The claim is beyond that. It's not just that our clients were in a position where they could not feel confident that their vote counted, and
Why?
there was no enforcement mechanism to check it.
The
But
votes
it-
were cast and counted. The question is, what are you saying their vote wasn't counted? What fact are you relying on that your plaintiff's vote was not counted?
It's just a the problem I think we're all having, it's just a boilerplate conclusion that you've come in with, and the same boilerplate conclusion would be that somebody, any person off the street, or anybody who ever voted in an election could make the same claim. Say, I voted, my vote was diluted, but I mean, the whole claim of injury, there has to be some distinctiveness to it, some uniqueness to it, something that differentiates you from the hundreds of thousands, millions of people who vote in an election. Some evidence exactly how your vote was diluted, exactly how was it diluted? I mean, what reasonable efforts were not undertaken? And how did they affect you? There are just so many questions to be asked about this standing point, and it all gets down. I mean, most complaints are just vastly more particularized in terms of injury than this one. That's the problem.
Well, the remedy that we were seeking is an opportunity to remand and amend the complaint.
That's not the standard, just to set it straight. We have to look at your complaint and determine that you have sufficiently alleged a claim here. The Iqbal-Twombly standard tells us that. We apply the rules in terms of how do you do it in the context of a vote dilution or a blank or whatever. You have to be particularized. And when you look at your complaint, I mean, if you look at it, that's not even an allegation that anybody even actually voted somewhere, or some injury actually happened to someone. Or that when you're dealing with public information, you just simply say, well, somebody asked. And that's not enough. Complaints get dismissed all the time, but particularly in these cases where you don't have that particular language, unless you can point to it, this complaint, and I have it here before me, where it is particularized in making the allegations that are necessary under our existing law. Because there are cases replete telling you you can't do this.
The thrust of my argument was that these people conducted this examination and did not have any place to go to complain to. And when they went to the
And let me-
executive.
I'm not cutting you off, but I want to make sure you understand. I'm not challenging your argument. What I'm saying to you is it has to be in this complaint. It cannot be stand in front of us and tell us what your argument would be or what it could have been for the first time, or it has to be here because of the type of appeal this case is coming to us on. There's a motion, there's a dismissal for lack of standing. So then we turn to this complaint and says, well, okay, where are the allegations? So you have to, it's not an argument, it is a directing our attention to what's in this complaint that gives you that particularized pleading that allows you to move forward.
I have no further argument to make on that point. The complaint that I wanted to raise to the court is there was no executive authority to which to take the complaint. And
Yeah, but see, your complaint by its nature is a complaint about a system. You surveyed the system, assessed it, and found defects in the system, voting system, that adversely affected voting and the counting of voting and that type of thing. But when you bring a lawsuit, you say you didn't have any place to go. The obvious place to go is the legislature or the election commission, depending on their authority. I don't know in Maryland whether they have the authority to address these or whether they should be done by the legislature. But those are systemic claims. And the question is, you say you would be like to have a right to amend, but how were, let's start with the two individuals that you have here as part of the association. How were they affected? And the only thing I saw is that one of them had a fear that the ballot that she actually cast may have been blank, but she doesn't know. She just alleges that because there were X thousands of blank ballots cast, she doesn't know whether hers was. But that's the most you allege. The other thing you allege is that because of these defects, some people may have voted that shouldn't have, and your vote was diluted. Isn't that it?
Yes, and the lack of enforcement mechanism within Maryland.
I know, but that doesn't go to
the.
the injury. The injury is how your persons were injured. That's what we're start out with, case or controversy under Article 3, as you know, needs to have the parties coming to court have to be injured and have an injury that we can redress.
All right, thank you,
Thank you,
sir.
Your Honors.
Mr. Coburn?
Thank you, Your Honor. May it please the court. As you've noted, the appellant's complaint essentially does not differentiate Catherine Sullivan, because Catherine Sullivan is the registered voter that the complaint names, does not differentiate Ms. Sullivan from any other registered voter in Maryland. It essentially alleges that there are provisions of the National Voter Registration Act and the Help America Vote Act that they allege were violated, and that a federal court should therefore enforce those provisions as appellants see fit.
Does the Maryland Board of Elections have the authority to address their complaints about the system?
Yes.
Did they file a complaint before the board?
No, they did not. The Help America Vote Act requires that states that accepted federal funding to update their election system have an administrative complaint procedure for filing these types of complaints. The procedures for doing so are in the Code of Maryland Regulations.
I mean, they've demonstrated, I think, they don't want to poo-poo it, they've demonstrated legitimate concerns about the voting system. The real question is, they've addressed the system as opposed to individuals who are bringing suit. And if you're addressing the system as it applies to all Marylanders, they should be going to some place in the executive side of things where, or in the legislative side, where you can either change the law or you can execute the law differently. And it seems to me those are the obvious things and they can do. And if they haven't filed a complaint, maybe you should go over and have them, invite them to send in their complaint.
My duties as an Assistant Attorney General in Maryland only allow me to help so much in a case like this.
No, it's helping the whole system.
Of course.
Yeah.
But ultimately, Your Honor is absolutely correct. What we have here is a generalized complaint about the system that does not particularize to either the organization or the registered voter named. There are complaints, again, under the National Voter Registration Act that essentially say there are inaccurate voter registration records, and that leads to dilution. And I just want to take a moment to point out for the court that even there, voter registration records do not lead to vote dilution. Vote dilution could be claimed as an injury in some way, like it is in.
Well, if you
unfortunate
compare it to
cases.
somebody else, I mean, like a race or a district, this district or that
Absolutely.
district, yeah.
If it's compared to a
But this
district or
is
within
a
a district.
statewide challenge.
Exactly, and
Yeah.
that's why
Well, I understand
a
that.
voter registration record won't get you there. Similarly, under the Help America Vote Act, which contains no private cause of action, it is a standards act, essentially, for election officials to conduct elections. The complaint about blank ballots is premised on two hypothetical conditions. The first being that ballot scanners were not configured properly to report undervotes or blank ballots, and two, that Ms. Sullivan herself unknowingly cast a blank ballot when there must be some personal responsibility. Ms. Sullivan
She didn't
cast
say
the
she
ballot.
unknowingly cast it. She said she fears.
She fears it.
She had no basis to fear it. She just said didn't know.
Which
But
is-
there's no way she's gonna ever know.
Which is fair. However, what she doesn't particularize is how she voted The notification requirement under the Help America Vote Act first applies to overvoting, to filling in too many bubbles.
Does
in
it
a
even
race.
state whether she did vote?
Well, it does not. I think the
There's no
most
statement that
generous.
she even voted in the election.
The most generous and liberal reading you can give to, I think it's paragraph 84 in the complaint, is that a ballot was cast. But no, the complaint never actually alleges that Ms. Sullivan voted in any Maryland election. And just briefly, as to Mr. Morseberger, who's the other registered voter argued in the briefs, Mr. Morseberger is not mentioned in this complaint. Mr. Morseberger filed an affidavit attached to a request for a temporary injunction, but never actually affirmed that he was a member of the organization. The plaintiffs here are not individuals. The plaintiffs are only Maryland Election Integrity and United Southern Americans. We therefore need an individual member of one of those organizations to have standing in order for those organizations to have standing. We don't have that here. Unless the court has any other questions about any of the other matters in this case, I'll submit.
All right, I'm going to ask my colleagues if they have further questions. We're fine, thank you. Mr. Castor? All right, thank you. We will adjourn court and we will come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.